you so much for joining me on my program once again. I appreciate you wherever you're joining me from. I say good morning, good afternoon, good evening. Accept my greeting according to your time zone. If you have not subscribed to my channel, please kindly subscribe to my channel. Click the notification bell so that you'll be notified each time I upload a video. You can be among the first to receive it. Then go to the comment section at all times. Leave your comment, drop your contribution. If you have suggestions, make it out there. If you have any criticism, put it down on the comment section. It will make us to get better, presenting you a better program.
Longer for the courts, but judiciary authorities are already warning against that, given the state of the nation. Senior lawyers Olisa Agbakoba and Femi Falamno, both of them senior advocates of Nigeria, well, they've called for petitions to be decided before inaugurations are held. There have also been calls for a live telecast of the presidential election petition tribunals and the sittings. And we have Michael Anduaka, the senior advocate of Nigeria, former Attorney General of the Federation and Minister of Justice, joining us now on the program. Great to have you with us. Thank you for joining us on Newsday.
Thank you very much.
Well, we have spent a chunk of the program discussing judicial reforms before you joined. There's a current discourse on the severe need for these judicial reforms. How could that help in these processes that we are about to encounter?
Well, generally, judicial reforms have been a continuous process. And mind you, any alteration of the Constitution amounts to a kind of judicial reforms. The judges instead generally interpret what the legislature has enacted. But generally, everybody's expectation is for quick dispensation of justice. And I think the reforms have to do more with procedural rules. For instance, in matters of election petition or pre-election petition, it would be desirable to do away with preliminary objections being taken separately and the judgments being taken separately. We would appreciate that reforms should go deep in solving that problem where people went to court, presented petitions, preliminary objections were filed to the petitions, they took time to hear the matters on merit. Just for judges, some rulings came that the matters were struck out just on the issue of the preliminary objection, and no judgment was given on merit. The overall effect of this was that most of the plaintiffs who went to the higher court could not get remedy because 180 days had expired. Most of the cases dragged at the lower court, pre-election petition dragged at the lower court to the full 180 days. It was naturally expected that judgment would be given on merit, even if the trial court opposed the preliminary objection. But in most cases, after taking full 180 days, the judge will come with one page, I agree with the preliminary objection, and I've struck out the matter. When the person goes on appeal, the Court of Appeal, in their wisdom and correctly too, say if I repeat the case, the 180 days constitutional provision have expired. So there has been very great injustice, and these reforms, there's need for us to look at that aspect. And also, in my opinion, like other countries, I have been wondering why the governorship election tribunal goes to 3 stages. When I was Attorney General, such a proposal came, but I turned it down because I saw the presidential election tribunal starting from Court of Appeal and ending in the Supreme Court. All other elections started from a tribunal and end at the Court of Appeal. So I did not see any justification why the governorship election will go to 3 stages: tribunal, court of appeal, and Supreme Court. So that is another area we have to make some reforms. There should not be such a disparity. If at all there's going to be a disparity, it should have been the presidential election, and amendment may be effected so that the Supreme Court hears once and forever as a court of first instance.
All right, very good.
So that is some of the comments I've made.
Very good, Mr. Ndoka. Now, let's talk about 2 issues here: the televising of presidential tribunal deliberations and ensuring all litigations are closed before swearing in. Is it possible to achieve this, you think?
First, the issue of televising is desirable, but proceedings of the courts are open and everybody has access to it. The issue is now, do the Supreme Court or the tribunals, like the presidential tribunal, do they have the resources and the equipments to start televising now? But the constitutional provision is met. Trial should be an open court. Parties should have access to it. And that is exactly what the presidential tribunal is doing. Coming to the issue of whether the trial should finish before swearing is highly desirable. But it does not violate the Constitution if it does not finish. Because the Constitution says the trial should take 180 days. And I don't see any problem in that. The reason is that if the court of first instance, in case of presidential, which is the court of appeal, gives judgment, even if the election is nullified, and the president-elect appeals to the Supreme Court, he will remain as president. And the presidential, the Supreme Court gives a decision. So we must allow the judges to operate within the ambit of the Constitution. The constitutional provision has been that do everything at the court of first instance within 180 days. Of course, issues are commenced by written summons. Testimonies have to be given. The judges have to evaluate. The judges are doing handwriting. So we must appreciate the special circumstances the judges found themselves. It's not just one presidential petition. I think there's a couple up to 3, 4 presidential petitions. And then to say that do them before the swearing in, I don't find it conceivable. And when I was Attorney General, there was a presidential election petition that dragged on until 1 year before judgment was given. And that is the wisdom National Assembly tried to abridge time and say, look, do presidential election tribunal, which is the court of appeal, 180 days. Do the appeal 60 days. It has already shortened the 1 year or the 2 years the election petitions used to drag on. So I think we must use wisdom. All the people that wish that the election should finish before the swearing is desirable. And that is why I say there's one area we must look at. Most countries, they take presidential election straight at one shot at the Supreme Court because the whole country is waiting. So maybe because of the desire by this of the public to have this hate tempestuously, we should look at, in the course of our judicial review, look at whether we can separate the presidential election, amend the Constitution, and make the filing of presidential election petition be at the Supreme Court as court of first instance and final. Just as you can see beside, it's done in Kenya, and most other countries, disputes relating to elections, presidential election, are filed directly at the Supreme Court. At least that is one window we can look at. And I have said this, it is obviously desirable to have the election tribunal finish before the swearing, but it may not be practically possible because the judges are human beings. The volumes of authorities have been cited. And of course, some authorities may even be overruled, or the Supreme Court may have reasons to depart from their previous decisions based on the authorities. Years have passed, things that have changed, the nature of amendment that occurred in the Constitution. Some of the authorities may not be applicable. Also, you look at the Electoral Act, some of the authorities that were delivered may not be applicable now. But one key thing that strengthened, I think the judges should be allowed to look at whether they can strengthen the process of election. Because emphasis have always been on the result of the election, not knowing that a corrupt process also can produce a system that cannot stand. And I think this is a window that everybody should be cautioned to allow the judges start from the process in looking at the grounds that deals with corrupt practices and non-compliance. Let the judges look at the process and see whether they can lay a solid foundation for this country, that if the process is strengthened, then the result that comes from a very sound foundation will be credible. I think that's what we should have concerned everybody. Because if we don't say, rush, do the election, look at the result, and decide, I don't think we are missing the point. And that is the point we have always been missing. Because the law should be looked from the foundation, which envisages that elections should be free and fair, as stipulated in the Constitution. The judges should look, because we have done it over and over in the country. And time has come to allow the Supreme Court or the judges in their wisdom look at the whole process and lay a solid foundation, looking at the process that strengthened and creates a solid foundation for a credible result for the parties who participated in the election. And I think that this should not be done in a hurry. It should be done within the 180 days as stipulated by the Constitution.
All right. And still speaking on these processes, our outgoing president, Buhari, well, he promised to deliver these free and fair elections, but with 436 election cases strewn across 27 states, I guess I can ask whether or not he has achieved any semblance of that.
That is the main issue the courts have to determine. You promise free and fair election, and so many petitions are before the court, from presidential, for senatorial, governorship, and therefore the courts will determine whether the process that led to these results were credible from the constitutional provisions, from the provisions of the Electoral Act, and then the results. Because mind you, if you say you base election based on only the result, then there's a problem. The problem is that you do not care how the result is arrived at. Because people can sit anywhere, do the result, do anything they want, and feel that they violate the process. But we have judicial authorities that say that the process for the election is as important as the result. And that's what I wish everybody to calm down. Let us see what the president promised. From the decision coming out from the various tribunals, we know whether the process was actually complied with to give a credible election. For now, judgment will prejudice the cases in court. But of course, the volume of cases, it takes a lot. But of course, Nigerians also like going to court. Let me tell you an instant. When I was Attorney General, I felt there was no need to abridge time to file election petition. Because Nigerians, when they're in court, the tendency of violence is less. are taking the man to court. And so the supporters do not engage in violent activities. And that's one area I will also use to talk about, even though you have not asked me. Everybody has gone to court. And I feel there's no reasons not to follow the constitutional provision, but to keep the process. One laughable argument has been presented is that interim government. I don't see the basis for that. People who elected to go to tribunal have taken to follow the due process. And the provisions exist for trial and judgment. And provision exists that in the event of even a presidential election is nullified, there's a provision that of who will become the president and election will be, acting president election will be conducted. So I think those who drop these ideas of interim government or whatever are overheating the system, and they are actually violating the constitution. Because everything relating to election in the country is specified. How the winner or how the loser will conduct himself is specified in the Constitution and the Electoral Act. And how in the event election is nullified, what happens? We have had instances at the governorship level where elections have been nullified and fresh election ordered. And we have instances where the speaker becomes the governor. It's just that we have never had an instance where the presidential election is nullified. But the provisions are all identical. So it is expected that in event anything like happen, there's a mechanism for the country to move on and wait for another election within 3 months. But for now, there's a presumption that the person who won the election is regular. You know, there's a presumption of public officers. If a public officer does a thing, even in your eyes, you will look at it as irregular, but there's a presumption in his favor. Until though you who is challenging that he did not follow the due process proves that in court, then until it's proved. So those who are overheating the system of interim government have no basis on it, because the tribunal did not. It's a subtle intimidation to the judges, and I don't think it's necessary. It's a desirable thing, but they should also realize the volume of work the judges have. And how would you expect them to treat presidential elections that are up to 4 to 5 and then finish within 180 days and then go on appeal to Supreme Court and finish within 60 days and deliver and finish before the handing over when we have less than 50 days?
All right. Still talking about the...
This is an angle that I think...
Very good. We're still talking about the workload of the justices. There are just 14 justices in the apex court instead of the 21 stipulated by the Constitution. Will it change anything here? Briefly, sir.
Well, that is very unfortunate. We expected the judges of the Supreme Court to have been appointed, but the process appointed rests on the NJC. I don't know really what happened. And I had expected that at least with what was coming, we would have a full complement of the Supreme Court. Unfortunately, that is not done, and certainly it has affected the judges, the 14 judges. Let me give you an instance what happened, the crazy and crazy thing that happened. In Nigeria, House of Assembly election goes pre-election, went up to Supreme Court. That's one aspect we can also make reforms in our electoral process. House of Assembly ought not to pass court of appeal. But it went to election, pre-election on House of Assembly went up to Supreme Court. And literally, every pre-election matter went to Supreme Court. So can you imagine, these people had just gone out of this problem. The whole country channeling pre-election matters up to the Supreme Court. And now the presidential election has come. Literally everybody who lost have gone to court. Nobody is ready to accept defeat. Most of the people have gone to court. It's going to go all the hog again for House of Assembly, Senate, House of Rep. It will stop at the Court of Appeal. But for strange reasons, governors will go three-hog: tribunal, court of appeal to Supreme Court, which I think it is wrong. They ought to have stopped at the Supreme Court as originally designed in the Constitution. They ought to have stopped at the Court of Appeal as originally designed it. So these are the areas I say the 14 judges, how will you expect them to cope? Even at the Court of Appeal, they were expected to have more judges. Interviews were supposed to have done, but it's not yet done. So the workforce on these people is so much enormous. Then we have, I think, the Nigerian Bar Association and senior lawyers like Agbakobo Falana, we have all been talking that let's create a report system and a conducive working conditions for the judges. At least electronic recording to reduce handwriting. But it's not done. Go to the Supreme Court, it's not done. These judges are taking manual notes. Go to Court of Appeal, they're taking manual notes. So these fundamental issues should be incorporated in our judicial reforms so that this long writing should be completely in the 21st century, should not be the order of the day. It's even more convenient.
Yeah, it's certainly it's certainly a Herculean task ahead of everyone. Thank you so much for joining us. We have run out of time, but it's good to have you, Michael Andoaka, former Attorney General of the Federation and Minister of Justice.